Call the meeting to order, and my apologies to witnesses for being a little late, considerably late starting. We had votes in the House, as you probably know. Pursuant to the order of reference, on Monday, January 29th, we'll continue our study on the Proceeds of Crime and Terrorism, the statutory review on the Proceeds of Crime and Terrorism Financing Act. And with us, we'll start first with the witnesses from the Canada Revenue Agency, Mr. Manconi, Mr. Bland, and Mr. Bonin. Go ahead. The floor is yours.
Good afternoon, Mr. Chairperson. Thank you very much for the invitation to appear before you today. My name is Tony Manconi, and I'm the Director General of the Charities Directorate within the Canada Revenue Agency. Je suis accompagné d'Alistair Bland.
With me is Alistair Bland, Director of the Review and Analysis Division, which is the area responsible for carrying out the Charities Directorate's national security mandate. Also from the CRA is Stéphane Bonin, Director of the Criminal Investigations Division. I will be sharing my speaking time with him today.
Here today to answer any questions you may have regarding CRA's involvement with the Proceeds of Crime, Money Laundering, and Terrorist Financing Act, PCML-TFA, as FINTRAC discloses information to two distinct areas within the CRA. When FINTRAC has reasonable grounds to suspect that information would be relevant to money laundering and to also tax and evasion, it discloses that information to the CRA's Criminal Investigations Division. My colleague, Mr. Bonin, will speak more about that role in a moment. In addition, when FINTRAC has reasonable grounds to suspect that information would be relevant to the risk of terrorist abuse of the charitable sector, it discloses that information to the CRA's Charities Directorate. J'aimerais maintenant vous donner un aperçu.
I would now like to provide an overview of the Charities Directorate's general mandate, as well as its role as a national security partner in Canada's anti-money laundering and counter-terrorism financing regime.
Constitution, the provinces have jurisdiction over the establishment, maintenance, and management of charities. However, registered charities are afforded certain privileges under the Income Tax Act, including exemption from paying tax on income and the ability to issue tax receipts for donations they receive. It's because of these privileges that the CRA has been overseeing the conduct of charities since 1967. The Charities Directorate is responsible for ensuring that registered charities meet the legal requirements for registration under the Income Tax Act. This includes ensuring the charitable organization registration only benefits those organizations that are exclusively charitable at law, and that charitable donations reach intended legitimate beneficiaries. We achieve this through a balanced program of education, service, and reasonable enforcement. Dans le cadre de ce travail, la direction de l'organisation.
In the course of its work, the Charities Directorate has been determining whether the registration system was being abused by individuals or groups having links to terrorist organizations. Various statutory developments have assisted in this endeavor.
Charities Registration Security Information Act, the Public Security and Anti-Terrorism Initiative, the PCML-TFA, and the Security of Information Sharing Act, as well as consequential amendments to the Income Tax Act, have provided the CRA with the mandate and the ability to staff a dedicated team within the Charities Directorate called the Revenue and Analysis Division, focused on protecting the charitable sector from risk of terrorist abuse. These statutory developments also permit the use of classified information for determining whether charities should be registered under the Income Tax Act, and have increased the CRA's ability to share relevant information with governing partners, including FINTRAC. While the Income Tax Act remains the primary authority for administrative decisions made by the Revenue and Analysis Division about charitable status, disclosures received from FINTRAC under the PCML-TFA contribute valuable intelligence required to make informed decisions. I now turn to my colleague, Stéphane Bonin, who will speak about Criminal Investigations Division.
Good afternoon, Mr. Chairperson. Je suis Stéphane Bonin, Directeur de la Division des Enquêtes.
My name is Stéphane Bonin, and I'm the Director of the Criminal Investigations team. Thank you for giving me the opportunity to speak to you about our participation in Canada's anti-money laundering regime.
Cases of tax evasions are investigated and, where appropriate, refer to the Public Prosecution Services of Canada for criminal prosecution. We use a risk-based approach for file selection on significant cases of tax evasion with an international element. Promoters of sophisticated and well-organized tax schemes aim at defrauding the government. Joint financial crime cases with other law enforcement agencies, including cases involving money laundering and terrorist financing, and significant or material cases involving income tax or GST evasion, including the underground economy. From a broader perspective, offshore tax evasion, which also may lead to money laundering charges, has become more complex, global, and aggressive, thereby presenting increased challenges to tax administration around the world. To address these new challenges, the Criminal Investigations Program went through a complete business transformation in 2013-14, going from 32 small offices across Canada to 6 large offices. The objective of the transformation was to strategically position its 600 resources in larger units across the country with offices in Halifax, Montreal, Ottawa, Toronto, Calgary, and Vancouver. Now, with a greater critical mass of investigators in larger centers, being closer with our primary partners such as the PPSC and the RCMP, CRA criminal investigation are now well positioned to meet current and future challenges. À titre d'exemple, les enquêtes criminelles de l'ARC ont récemment
As an example, the CRA Criminal Investigations recently executed 3 search warrants during the course of an offshore tax evasion criminal investigation related to the data leak from the Panamanian law firm and corporate service provider Mossack Fonseca made public in the Panama Papers. Approximately 30 CRA criminal investigators, assisted by members of the RCMP, took part in the operation that unfolded in Calgary, West Vancouver, and the GTA. The CRA's investigation identified a series of transactions involving foreign corporations and several transfers through offshore bank accounts used allegedly to evade taxes. In our media release, the CRA publicly acknowledged the significant contribution of the Financial Transactions and Reports Analysis Centre of Canada, FINTRAC, to this criminal investigation. This example demonstrates the effectiveness of various regime partners working together. Domestically, the CRA collaborates with FINTRAC and law enforcement agencies to ensure the effective use of financial intelligence in its criminal investigations. As my colleague Mr. Manconi mentioned earlier, the CRA receives disclosures from FINTRAC when they suspect that information would be relevant to money laundering and also to tax evasion.
Chairman, tackling this global problem of tax evasions and money laundering takes a firm commitment and the effective use of tools and partnership to identify and bring into compliance those who try to cheat and misuse the system, which is why the CRA Criminal Investigations Program remains a committed partner in the anti-money laundering regime and will continue to investigate those taxpayers who participate in money laundering to tax evasion. I look forward to your question.
Thank you. Mr. Blanc, okay, that's great. Thank you then to the representative of the CRA. Turning to the Office of the Privacy Commissioner of Canada, Mr. Theron, Ms. Wilson, and Ms. Ives. Welcome.
Merci, Monsieur le Président. Je vous remercie.
Thank you, Mr. Chair. Thank you for giving me the opportunity to appear before you today as part of your statutory review of the proceeds of crime. Of course, straight off, I would say that in the Commission, we support Canada's efforts to combat money laundering and terrorist financing. However, the manner in which these efforts are undertaken must strike an appropriate balance between the need to combat such activities and respecting privacy rights of Canadians. The most apparent privacy implication with this regime is that it casts a wide net, capturing a great deal of information about law-abiding Canadians conducting financial transactions, with a view to uncovering threats to national security or incidents of money laundering. In our previous briefs on Bills C-51 and C-59, we signaled concerns about information collection and sharing regimes in the context of national security. Specifically, we highlighted the need for rigorous legal standards around the collection and sharing of personal information, effective oversight, and minimization of risks to the privacy of law-abiding Canadians, in part through prudent retention and destruction practices. As you are aware, subsection 72.2 of the PCM-LTFA provides my office with a mandate to conduct biennial reviews on how FINTRAC protects information it receives and collects under the Act. We can also conduct reviews under Section 37 of our law, in other words, the Privacy Act. All of our audits to date have identified issues with FINTRAC receiving and retaining reports which do not meet legislative thresholds for reporting. In 2014, the PCM-LTFA was amended by Bill C-31 to add subsection 54.2, which requires that FINTRAC destroy information in its holdings which was either not required to be reported or any information voluntarily provided. Although FINTRAC has implemented measures to validate incoming reports, resulting in the rejection of thousands of them, we continue to identify information in FINTRAC databases that did not meet thresholds and should not have been retained. Also, we have generally found FINTRAC to have a comprehensive approach to security, including controls to safeguard personal information. Our most recent audit did identify governance issues between FINTRAC and Shared Services Canada, which FINTRAC has committed to addressing. Beyond these issues, which we are mandated to review under the PCM-LTFA, our principal concern, based on our experience reviewing FINTRAC over the past 10 years, relates to the lack of proportionality of the regime. Disclosures to law enforcement and other investigative agencies made in a given fiscal year represent a very small number when compared to the information received during that same time frame. Information received is also retained for longer periods, for 10,000 reports that were received. So, FINTRAC's retention of undisclosed reports increased from 5 to 10 years in 2007. Even if one accepts that sharing financial transaction data related to law-abiding citizens may lead to the identification of threats of money laundering or terrorist financing activities, once that information is analyzed and leads to the conclusion that someone is not a threat, it should no longer be retained. More broadly, we have noted a trend to broaden the regime over the years. And this was recently confirmed in the Department of Finance, which is tending toward a more global approach of data that would allow for increased data sharing. If current thresholds were lowered, that has already been discussed. And in the discussion paper, the Department of Finance also proposes increasing the number of organizations that have to declare and setting up a new model to engage with the private sector.
Approach to the collection and sharing of information might be useful to identify threats. What is proposed, unless appropriate privacy safeguards are adopted, would further exacerbate our concerns with proportionality. Instead, I would suggest that a risk-based approach be adopted in order to minimize the risk of over-collecting and retaining the financial and personal information of law-abiding citizens. Under such an approach, FINTRAC, based on a thorough risk-based analysis of its data, would develop criteria to limit collection, sharing, and retention to only situations likely to represent potential manifestations of terrorist financing or money laundering. We realize this may be challenging, but as privacy experts, we at the OPC believe we can play a role in the assessment of these factors. Which leads me to this. Currently, our review mandate under the PCM-LTFA and the Privacy Act is limited to ensuring that these statutes and regulations, as enacted, including monetary thresholds for collection, are respected. We think a more useful contribution would be to provide advice after review on amendments that could be made either to the statutes, to the regulations, or to practices of FINTRAC to ensure greater proportionality, including the assessment of risk factors which might govern information collection, sharing, and retention. The government is recommending that the PCML TFA be amended to provide that the reviews we currently undertake every 2 years under Section 72 now occur every 4 years. We agree in part, but we would recommend a change of purpose for these reviews. So point one, we would recommend that the purpose of our reviews under the Act be modified to include advice or recommendations on proportionality, as just mentioned. Second, that they begin at least 1 year before every anticipated 5-year review that Parliament must undertake. The OPC would continue to conduct compliance reviews under Section 37 of the Privacy Act, which would not need to be amended. As it relates to proportionality, the committee may wish to consider Part 4 of Bill C-59, currently before Parliament, concerning CSIS data sets and their retention, which might be instructive. Under that model, CSIS must screen data promptly, that is, within 90 days, and can only retain Canadian data sets if the federal court is satisfied it is likely to assist in the performance of CSIS's mandate, including the detection of threats to the national security of Canada. In addition, with respect to any contemplated changes to reduce existing thresholds through regulations, which would also affect proportionality, I would reiterate my recommendation in the context of Privacy Act reform that government institutions should be legally required to consult with my office on draft legislation and regulations with privacy implications before they are tabled. My written statement now goes into questions of oversight. Do I have time to?
Go ahead.
In terms of review and oversight of this regime, there are some review mechanisms in place and others proposed in Bill C-59, but I would argue that there are still some gaps in terms of comprehensive oversight. While some decisions are subject to statutory or judicial review by the federal courts, so that's one form of oversight by the courts, a decision by FINTRAC to disclose information is more likely to be challenged in the context of a proceeding involving a disclosure to an investigative body, such as a law enforcement agency. In many cases, however, an individual whose information is disclosed by FINTRAC may never know the disclosure took place. C-59, if passed, would create a new expert review body, the National Security Intelligence Review Agency, with broad jurisdiction to examine the activities of all departments and agencies involved in national security, which include FINTRAC. In addition, the new National Security and Intelligence Committee of Parliamentarians will also have a role to produce well-informed and comprehensive reviews of the work of these agencies. However, the NSIRA will not review all of FINTRAC's activities, given the latter's mandate to identify criminality related to money laundering and the NSIRA's national security mandate. Its national security review may also be limited, given that not all of FINTRAC's disclosures are within the federal family. The OPC is another oversight mechanism. We have an important mandated role, as already examined, and insight on the privacy aspects, including 10 years of audit experience in this area. However, as we've said in the context of Bill C-59, we currently would not have the legal authority to work with other national security review bodies, such as the NSIRA, to cooperate and provide effective oversight in this area. So to summarize, I would recommend the following. One, that the purpose of our reviews under the PCML TFA be modified to include advice on recommendations on proportionality. Second, that they begin at least 1 year before every anticipated 5-year review that Parliament must undertake. And third, with respect to any contemplated changes to regulations, Finance Canada should be legally required to consult with my office on draft legislation or regulations with privacy implications before they are tabled. Thank you very much, and I look forward to your questions.
Thank you very much. Turning then to the Department of Public Works and Government Services, Mr. Trudel and Ms. Thompson.
Thank you. Bonjour, Monsieur le Président. Je m'appelle Lynn.
Good afternoon, Mr. Chair. My name is Lynn Thompson. I'm the Director General of the Integrity Regime and Financial Accounting Management Group of Public Services and Procurement Canada, or PSPC. Accompanying me is Mr. Nicolas Trudel, Director General with the Department's Specialized Service Sector.
As the Government of Canada's central purchasing agent and real property manager on behalf of all government departments and agencies. PSPC also provides specialized services to other departments and agencies. It is in the second context that the department directly supports Canada's anti-money laundering and anti-terrorist financing regime. PSPC provides two services that are directly linked to the Proceeds of Crime and Terrorist Financing Act. The first of these services is forensic accounting, which is delivered through Forensic Accounting Management Group of the Integrity Regime Renewal Branch within PSPC. The second service is the disposal of seized property. This is managed through the Seized Property Management Directorate of the Integrated Services Branch, which Nicolas will speak to briefly. I'd like to share with you now a bit of background on the Forensic Accounting Management Group, or FAMG. It was created in 1998 following the implementation of the Proceeds of Crime Act to support both the Royal Canadian Mounted Police and the Prosecution Service in relation to proceeds of crime or money laundering investigations. Through a 2002 Order in Council, the provision of forensic accounting services by the Minister of Public Works and Government Services Canada to provincial, territorial, municipal, and Aboriginal governments and their police forces and foreign governments upon request by these governments for such services. Across Canada, approximately 40 forensic accountants are co-located with the RCMP in 11 of their offices. They play an active support role in the detection and distribution of money laundering and terrorist financing by collecting and assembling financial evidence to support or refute allegations. Their analysis of financial transactions help lead to the identification of wrongdoers, provides evidence for the elements of the crime, and allows law enforcement to trace and seize any ill-gotten gains. These accountants also provide advice on various financial and accounting aspects of the investigation, including analysis of corporate documents, banking data, tax information, financial statements, and FINTRAC disclosures. Pour vous donner une idée de l'envergure de ce travail,
to give you a sense of the vast scope of this work, in the past 5 years, the group has been involved in approximately 100 RCMP money laundering and terrorist financing investigations, and has testified in nearly 30 criminal trials. The combined value of seized assets and court-imposed fines in these files totaled nearly $10 million. Money laundering and terrorist financing investigations have become increasingly complex and almost always include an international component. To share our knowledge in finance and accounting, we also work with the RCMP in order to provide specialized training to the investigators working on these files. In order to combat these crimes, it is important to remove the financial incentive. The analysis of financial transactions is a key part of that work. Therefore, the impact that forensic accounting services can have in money laundering and terrorist financing criminal investigations is significant and has been proven in Canada as well as internationally.
PSPC indirectly supports the objectives of the Proceeds of Crime and Terrorist Financing Act, as it is responsible for administering the Government of Canada's integrity regime. This regime ensures that the government does business with ethical suppliers and that suppliers who have been convicted of listed offences are rendered ineligible to be awarded a government contract. Fitting with the duties of my group, one of the listed offences is convictions of laundering proceeds of crime. I will now turn to my colleague who will speak to you about the management of seized property.
Thank you. Bonjour, Monsieur le Président.
Good afternoon, Mr. Chair.
Director General of the Specialized Services Sector within Public Services and Procurement Canada. I've been responsible for the Seized Property Management Directorate, which I refer to as SPMD, since 2014. My intention today is to give you a brief overview of the organization and the extent of our involvement with regard to the Proceeds of Crime, Money Laundering, and Terrorism Financing Act. SPMD was created in 1993 to support law enforcement agencies across Canada and abroad with the management of seized and restrained assets. SPMD provides several critical services to stakeholders. The Directorate provides consultative advice at the pre-seizure, post-seizure, and post-forfeiture stages. At the pre-seizure stage, this involves providing financial, logistical, and risk analysis to stakeholders and includes consideration of the overall financial viability of seizing an asset. At the post-seizure stage, sound asset stewardship practices are applied to protect, maintain, and report on seized assets. And during the post-forfeiture stage, when directed by the courts, the disposal of the asset occurs either by public sale, donation, recycling, destruction, or return of the asset to the accused. SPMD also administers the sharing of net proceeds with stakeholders. Proceeds are generated by disposing of seized assets or collecting fines ordered by the courts in lieu of forfeiture. Sharing occurs with jurisdictions that had a law enforcement agency participating in the investigation of offenses. From 1993 to 2017, SPMD shared a total of $337 million in net proceeds, which includes $243 million with the Receiver General of Canada, $89 million transferred to provinces and territories, and $5 million shared with foreign governments. The legislative authority governing SPMD includes the Seized Property Management Act and its regulations, the Controlled Drugs and Substances Act, and the Criminal Code of Canada, as well as the Proceeds of Crime, Money Laundering, and Terrorism Financing Act. SPMD's authority under the PCML-TFA relates primarily to Sections 18 and 22 of the Act. Section 18.1 authorizes seizure of currency or monetary instruments by law enforcement agents with reasonable grounds. Section 18.2 requires a return of seized currency or monetary instruments where a penalty has been paid unless the assets are suspected to be proceeds of crime under the Criminal Code or funds for use in financing terrorism. Section 22.1 requires that forfeited currency or monetary instruments be sent to the Minister of Public Works and Government Services. And Section 22.2 requires that seized currency, monetary instruments, and penalties be sent to the Minister of Public Works and Government Services. I'm happy to answer any questions you may have about SPMD's role.
Thank you. Thank you to all the witnesses. The more witnesses we have, the more complex that we can then complicated we can certainly see this review is. Turning to Mr. Fergus, we'll go first round 7 minutes. Greg, the floor is yours.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chair, and thank you to all the witnesses who came today. I think it's very interesting for Canadians following today's session because they'll be able to identify some of the shortcomings in this issue that we're looking at. I think I'll start with Mr. Terrien. Thank you for your work and the work that you and your team are doing. Now, Mr. Terrien, you said in your opening remarks that your office had identified that there were some problems. I'm sorry, I only have the English version of your speech here.
The level of which information is retained by FINTRAC. Alors, puis en même temps, on écoute Madame Thompson.
And at the same time, Ms. Thompson from the department indicated that it's so important to have a way to verify this and to have forensic accounting. It seems to me that if you want to determine that there's been money laundering or terrorist funding, you need information, and fairly recent information perhaps, and perhaps less recent information, so that you can review that data and if something happens, you can go back and look at the data and the conclusions where perhaps someone said in the past, oh, it's fine, nothing happened here, there was no money laundering. But then as new information comes to light, you need to go back and look at that again. So do you think that FINTRAC should be eliminating that information immediately, even if there are some doubts about people's activities or companies' activities? Well, we're not necessarily recommending that these documents be destroyed very quickly. We are recommending a risk-based approach. So our starting point is that the collection of information about many transactions, the majority of which, of course, are conducted by law-abiding Canadians, in the goal of finding terrorists, is very similar to the approach in Bills C-51 and C-59. And of course, you do need to filter information based on different criteria in order to be able to identify threats and people who identify who represent a threat to safety. I'm not questioning that. What I am questioning is I'm saying, it's useful to keep the numbers in mind. I believe that last year the disclosure rate to law enforcement was 1 out of 10,000. So for every 10,000 reports received, only one actually ends up in the hands of law enforcement or at the CRA or at security agencies. So there is a lot of information that is collected in order to identify very few people who actually pose a threat. Now, I'm not saying that we should stop collecting data, but what I'm recommending, as members of the CRA have also partly suggested, is that we have a risk-based approach. So we can collect a lot of information at the beginning, but then we should adopt a risk-based approach that might keep some data for forensic evidence ends, but we do need to ask some questions. We need to be able to look at the risk early on to find out if we should be keeping this data or not. It's possible that for various reasons, some of these reports would need to be kept for a long period of time. But I think that many other reports should really be destroyed quite quickly, as Bill C-59 proposes. I see an analogy between the way C-59 works, where there's a very broad collection of information to identify very few people who are a threat, and the collection of financial transaction information under the PCML TFA. Because, again, here, very few people who are actually doing money laundering or terrorist funding are actually identified. Thank you very much. Madam Thompson, in your opinion, and according to the agency, do you think that you need to have information? And if so, how long do you need access to that information for in order to ensure that you can work with FINTRAC in identifying illicit activity? Well, we are mandated by the RCMP to help with criminal investigations. And so it depends on the facts and the activities of the case and over what period of time they occurred. I would say the more financial information we can have access to, the better and the easier it is for us to understand the source of the funding and the use of the money. And so to follow the trajectory and the path of the money from account to account. Are there shortcomings in terms of the information that you have? For example, do you think it would be better if you had more access to more information, if you weren't constrained by privacy measures? It's really more about the ability to identify who really owns the money or the goods. The beneficial ownership? Yes, exactly. So you want to identify who are the true owners. And you want to have access to domestic and international information. To do so, we have to work with the RCMP. So if money is in a foreign account, we have to work with the RCMP to find out where the money came from, trace it back, and then to work with Justice Canada to get access to that information.
Is it a supplementary?
No, it was
You may get another round than Mr. Albus.
Thank you very much, Mr. Chair. And I just want to thank all of our witnesses for the work you do for Canadians and appreciate your presence and expertise here at the table today. I would like to start first with Mr. Terrien. Thank you very much for your presentation. I'm going to be asking a couple of questions on what you've offered, but also being from British Columbia, I have some specific cases, but also I'd like to talk about, because these reviews happen every 5 years, technology changes and whatnot. And so let's just start off with, first of all, you've made the suggestion that right now FINTRAC collects information on every financial transaction that it can possibly get a hold on, that it's allowed to under law, and that there should be some proportionality perhaps applied. And so the question I would ask, does technology like algorithms allow for the risk-based assessment that you're talking about, or are you just talking about taking the current system and then slowly scoping it into a different framework vis-a-vis C-59?
Technology may well help to bring greater proportionality.
So is there technology like algorithms, AI or whatnot, that would be able to supplement right now? Because to me it seems that they capture a tremendous amount of information, that if there's a complaint made by someone, that they follow up with it. If there seems to be suspicious activity over a period of time, but they're retaining all of that information. I think that's the concern you've placed. And so could an algorithm be utilized that we could move off of this where you collect and hold all information? Or should there be, very similar to an airport scanner where everyone is scanned, but again, there are different tools that are done to when there are concerns raised?
I think it would likely be an iterative process. I can't say to you today, without having looked at the risk factors, what they would be, but we would like to sit down with FINTRAC, discuss with them whether they think there are certain risk factors that are more indicative of the activities that they must identify, and I'm sure there are, and we would work with them to identify what these risk factors, and potentially not collect information that would not lead to these risks. So we want to work with FINTRAC, in other words, to get to the right place.
I certainly appreciate that recommendation, and I'm glad that you've been here to explain it in full detail. Moving to British Columbia, obviously, an area that is under a lot of questions is real estate transactions. One of the questions is, should someone be able to purchase property without actually disclosing their ownership in it or beneficial ownership? Do you have any issues with privacy concerns when someone purchases a piece of property but does not disclose their information?
We don't have a problem with rules that would provide greater public information about beneficial ownership in principle. Of course, the data that would be made available to others, particularly the public, should be only limited to what is necessary to achieve the purpose of informing another potential contractual party to know with whom they are dealing, for instance. But in principle, we don't have a problem with that.
Okay, thank you. Just in regard to FINTRAC, there's obviously a great amount of money goes into making sure the system runs well. So there's a lot of compliance costs as well, but it does create a overriding societal benefit, I believe. But on the flip side, they're collecting a lot of information that could be aggregated in a way that does not compromise anyone's individual privacy, that may help decision makers, for example, CMHC or OSFI or even the Minister of Finance, because it captures information. For example, Mr. Graywall had raised at our housing study about cash purchases. Do you think that there's any risk in government looking to aggregate that data so that we have a better picture of some particular markets vis-a-vis real estate transactions?
If you're talking about information that would be aggregated and intelligence derived from that information would then be provided to others, presumably on an anonymous basis, not on a personal information basis, that again is possible in principle. There may be problems with anonymizing information. Often when you anonymize information, you can re-identify the individuals. So care would obviously need to be taken to do that rigorously. But in principle, yes, I think it's doable.
Okay, and so this goes back to your recommendation that being consulted as part of any upgrades to regulations would be helpful. Okay. No, that's very good to know. Now, Minister of Finance has recently started discussing the concept of open banking, and open banking could be a variety of different things. For example, in the United States, there's a service called Mint.com, which allows people, for no charge, to be able to directly link up to their financial data through their financial institution, and be able to draw everything from low-cost loans that are available based on their credit score or based on their income, as well as suggestions on potential vehicles for them to save for retirement, and as well as to save or to manage their expenses. And that's all done free. The question would be, obviously, that technology exists. It's being used in the UK as well as the European Union as well. We haven't seen that level of offering here, although I've met with Intuit, and they've said that while they have some similarities, they're operating off of very old technology. Now, the question would be, is first of all, privacy. Obviously, banks and financial institutions owe their clients privacy and protection. But on the flip side, do you think that therefore Canadians who would utilize such services would then, because it is their information, would they then own that information and could use it for their own purposes? Do you think that there's any questions for your office in the question of open banking and the ongoing retaining of that information by financial institutions, or that someone should be able to say that they own that information and it shouldn't be shared without their permission?
So I'll start by saying that I don't think my office has looked at the question of open banking with any details. I think we're outside the scope of the PCML TFA here, and we're probably dealing with the interactions between consumers and an organization subject to PIPEDA, the federal private sector privacy legislation. And there is a relationship, of course, between the individual whose personal information is collected by the bank and organization, and the data, if it is personal information, needs to be handled according to PIPEDA.
I would just suggest, though, that there is, again, a public purpose in FINTRAC monitoring those accounts. I would also say that there is a personal interest because that is that person's information. And if a bank or a third party that was to utilize their information for purposes other than what maybe that they've allowed, or perhaps they leave that financial institution, should they have a right to basically pull that information? Because it is their data, their financial transactions. And so I think actually it does relate to the study that we're talking about right now. I just wanted to make sure that we're identifying that there is a government need, obviously, to provide protection, but there's also an individual, and privacy is not just in terms of disclosure of information, but retaining the information and what it's done with it.
If I understand the premise correctly, and then the bank in this system would provide or would somehow facilitate FINTRAC or a government agency to have access to that information, that's the premise, then I think we need to look at the question of proportionality. So what harm are we trying to address by having the government have access to that information? It may be that there is an important harm, but I would want to look at the question of the harm quite seriously.
In your opinion, would own that information?
Dan, we're well over unless it's finishing this line of thought. Is your line of thought
just complete? In his opinion, because there's a difference between someone's disclosure of their identity, let's say under FINTRAC, or of their financial transactions, but the actual data itself, the transaction itself, is it owned by the financial institution, in your opinion, or is it owned by the consumer?
I think we're talking about personal information of the individual consumer, but that does not mean that you cannot create a system whereby the state would have access to some of that for important public policy reasons.
Okay, thank you. Mr. Dussel.
Merci, Monsieur le Président. Merci à tous pour être.
Thank you, Mr. Chair, and thank you all for being with us today. I'm going to be focusing on the CRA. I'm sure that'll be no surprise to my colleagues. These questions are really important, and I'm really here in good faith today to try and find solutions to help you, because, to be honest, I don't share your argument that criminal investigations against tax evasion are really doing well and being effective. I could refer to an article that came out before Christmas that said that in the 78 cases, or 78 convictions that there have been over the last 2 years, there were almost none that actually had to do with foreign tax evasion. So I don't think that that's a particularly great result. Now, in terms of helping you, if there is no national public registry of who actually it has the beneficial ownership of companies, for you, is that an impediment? And is that something that needs to be solved, this question of beneficial ownership? And would that allow you and others in Canada to have more rapid access to who owns which companies in Canada? Thank you for the question. As far as the question of beneficial ownership is concerned, it's clear that this is a hindrance to our investigations. However, I understand that the provincial finance ministers agreed to a framework so that they could work together to find solutions. And this may lead to a national registry with the goal of accomplishing that by July 2019. I think the agency would be favorable to the idea of a registry, but we have to work with the rules that we have. And concerning those 78 convictions that you mentioned, currently the CRA, the Criminal Investigations Branch, has over 340 investigations underway, including ones dealing with people abroad. So we are transforming the program. It has taken a while so far, that's true, but we currently have 42 investigations of offshore transactions. We find that they're going in the right direction. And I would also mention that there are 23 tax investigations that do touch on the proceeds of crime. So we are in line with the objectives of transforming that program. Thank you for that answer. I do hope that this will be done by July 2019. And I hope that the committee will join me in calling on the government to take action on this file. Now, certainly 42 investigations into offshore tax evasion is a start, but that's very far from being a great result. When things are at the investigation stage, often there's a cost-benefit analysis that's done by the department, and in some cases, it's decided not to go to court. It's decided to settle out of court without going before a judge. And many of these cases have to do with tax evasion. So I'm wondering if you'll be reviewing that process, as in the case of KPMG, or will you simply agree to settle for amounts that are significant, but are not being used as examples to show Canadians that tax evasion is unacceptable and that it will be prosecuted to the full extent of the law? Because if not, you're sending a contradictory message. First of all, I think it's useful to distinguish between audits that are conducted by the CRA and then the investigations that are conducted by the CRA. I'm here to talk about investigations today. And the directives that we have is to conclude investigations and then follow up with the criminal branch. So there hasn't been a follow-up with some of these files for tax evasion. Now, it's possible that there would be negotiations between the prosecutors, the PPSC prosecutors, but this is the case in any criminal case that comes before the courts. On the civil side, now, I mean, I'm not here today to talk about that. Oh, that's good. Thank you for the clarification. Now, concerning the Panama Papers, which you alluded to earlier, we know that there are a number of countries that have already managed to recover sums of money, and we are still at the investigation stage. Could you give an idea of how much longer it will take before this information is sent to the PPSC? And before we actually see sentences and fines being imposed by the people named in the Panama Papers? Well, again, in terms of audits, the audits related to the Panama Papers, my understanding is that there are currently 990 investigations into Canadian taxpayers, and when I say 990, that's 990 investigations of all taxpayers who have money abroad. Now, specific to the Panama Papers, there are 150 since December 31st. So you saw that there were search warrants a few weeks ago. To answer your question then, the agency has adopted an overall approach, a global approach, both in the civil and criminal sides. I'm confident that we will be able to move forward with prosecutions before the courts. This always takes a certain amount of time, but when it comes to audits, unfortunately, I don't know how much money they're planning on recovering. Different countries have different methods for that. Just very briefly, I'd like to know, in a broader sense, does the existence of the Paradise Paper, the existence of tax havens, does that represent a significant challenge for your investigators? And what are you doing to try to find solutions to the fact that it's often very difficult to see what's going on in these jurisdictions? Well, it's true. Things are sometimes murky and it's difficult to see what's going on there. Over the years, Canada has developed, I believe we have 93 tax agreements with different countries, and we also have other information sharing agreements, 23 of them, with countries that are recognized as being tax havens. Now, FINTRAC also plays a role here. When we started looking into the Panama Papers, now, of course, it's not illegal to be named in the Panama Papers. It's important to say that at the outset. We had a particular approach to the investigations, and, you know, if there's a Canadian taxpayer who's in the Panama Papers, then we start doing some checks. For example, did the person fill out the T1135 form, which is a form where you declare income abroad? So if the person was named in the Panama Papers, but didn't declare over $100,000 or didn't have over $100,000 in a foreign account, well, then we have to look into whether there's going to be an investigation rather. Then we go to see FINTRAC, and FINTRAC will give us the transactions. So we start with a structure, and then we proceed to internal checks. Then we get information from FINTRAC, And then we can have a good idea whether we're really dealing with tax evasion or not. If so, we pursue the investigation. So this is not insurmountable. It's true that it's difficult to know what's going on sometimes, but it's not an insurmountable problem.
That there we're substantially over. Mr. Francesco. Sabera.
Thank you, Chair. Thank you, Mr. Easter. Good afternoon, everyone, and welcome. First of all, to CRA, I wanted to say congratulations on your announcement a few weeks ago, which you referenced in your remarks today. I think it gives our committee and Canadians confidence that resources are being put to use to make sure all Canadians and all Canadian organizations are paying, or even foreign organizations are paying their share of taxes, and tax avoidance or tax evasion is being rooted. My first question is with regards in your comments in terms of the business transformation that took place in 2013, 2014. We all know the issues that can occur, whether in the private and public sector, when there is a sort of reorganization that occurs within a company or government agency. And I wanted to ask, how is that reorganization going? What do you think are the outcomes, and how has CRA and the teams and individuals there, how are they working better within the organization and between the agencies?
Thank you for the question. First, the business transformation was essential. I was looking yesterday, almost to the day, 6 years ago, to the day there was a committee appearance to review of the PCML TFA, and a former colleague who has since retired was here, and I think at that point it was made clear that CRA had to renew his criminal investigations program, and this is what we did. The purpose behind was we had 32 small offices conducting mostly small cases of tax evasion, and the desire at that point was how can we be closer to our partners, that it be the RCMP or the Securities Commission and others, and our public prosecution services of Canada to tackle the most egregious cases of tax evasion. So that was the driver behind how can we get greater critical mass of investigators, greater teams put together and tackle those large files that we are now doing. So that was the driver behind. Yes, for sure, realigning 32 offices in 6 offices, that we lost some expertise, and that was we knew we were losing some expertise. But at the same time, there was opportunity there to get new blood, new auditors, external talent at the same time, and that was also the same time that money laundering became a predicate, that tax evasion became a predicate offense to money laundering. So we train all of our folks as it relates to money laundering, to sensitize them about the money laundering components, and I think we are doing very good. There's still a lot of things that we can do better, but I think we are on the right track to conduct the type of investigations on the most egregious cases that Canadian expects of us.
Okay, and our government in our first 2 budgets invested nearly $1 billion into CRA, and when I think about that, it's giving CRA the tools and giving the people the tools and the systems needed to go after very complex, I think that was a term I read, forms of tax evasion and tax avoidance. Have those investments allowed these teams specifically in this area within CRA to effectively go after individuals or organizations undertaking tax evasion or tax avoidance?
There was a lot of investment that were put into CRA systems and business intelligence, considering now that almost 89% of Canadians file electronically. CRA had to step up and modernize its systems to ensure that what they have or what we have in our system can generate more cases or more indicators of tax evasion that will make its way eventually to the criminal investigations.
Okay. I could ask CRA several more questions, but I do want to spread the wealth around, if I can use that term. Over to the Office of the Privacy Commissioner of Canada. There was a report that was issued in believe September of 2017, the OPC released its audit report on FinTrack, and it concluded there was a significant efforts to enhance personal information handling practices. Now, I think there's a bigger issue. I think we live in a society where data is very valuable to organizations, and data sharing and data collection and data storage. And what I wanted to hear from yourselves is, in the last several years, have there been improvements from FinTrack's side in terms of how they handle personal information from Canadians?
The short answer is yes, although we still see some difficulties. Our mandate at the OPC is in part to verify whether FinTrack's security measures to protect the information that they collect, whether the security measures are appropriate and sound, and generally we find that they are sound. We've had concerns over the years with the fact that some financial institutions over-report to FinTrack and that FinTrack over-collects and over-retains information. This led to the amendment to the legislation that I referred to in my remarks, which was an improvement. So the situation has improved in that regard, but we still see, including in our most recent review, instances of over-retention.
May I follow up? If you can give me like an example, what is it, the length of time that they're holding the information, or is it just
the type of information? I'll ask Ms. Ives to give you an example.
Oh, please.
So it's a combination of things. Sorry, this is a bit loud. So it's a combination of things. We found reports that don't meet thresholds, so it will be underneath the financial thresholds, or which didn't obviously meet thresholds about suspicion, so that type of threshold as well. But the point is that if institutions are over-reporting to FinTrack, then we wish, or they should not be retaining that data. They have implemented measures to screen reports with validation rules, but there's still information getting into its databases that don't meet the threshold. So we would hope that it would not get into the databases in the first place. The provision that the Commissioner is referring to only imposes an obligation for them to dispose of information that comes across in its normal course of business. So we're suggesting something more proactive than that.
Okay, thank you. Is that? Yep.
Thank you all. Before I turn to Mr. Kelly, you mentioned, Mr. Theron, in your remarks, Bill C-59, and I kind of took it that you might have thought there needed to be amendments to C-59. Is what you're talking about there related to issues relative to money laundering and terrorism financing, or is that other issues related to privacy with the new security agency?
There are two things I'm saying about Bill C-59. One is, even though there are a number of oversight bodies overseeing FinTrack, and we, as one of the bodies, cannot legally share information that we collect in the course of our reviews with other review bodies, and we're saying that it would be very helpful to having fully informed reviews by us and other review bodies if we were able to share our work and come up with more informed conclusions. That's one point. The other point is the analogy with CSIS collection and retention rules, Part 4 of Bill C-59, where there is some analogy, I think, to FinTrack and the PCML TFA, where under Part 4 of Bill C-59, CSIS can collect a whole lot of information, considerable information, much of which is about law-abiding citizens, as FinTrack collects a lot of financial transactions about law-abiding citizens. But under Part 4 of Bill C-59, there are mechanisms to ensure that that data that is collected is reviewed fairly promptly to determine whether it is of probative or investigative value, and if it is not of investigative value, then it must be discarded. So I think that's an interesting compromise between where you have broad collection, but screening fairly promptly, leading to not unduly long retention of information regarding law-abiding citizens.
Okay, thank you. Really what I'm trying to get at, if things that are being done via C-59 are important to moving ahead on money laundering and terrorism financing, which is our review, then they need to be done fairly quickly because that committee will be starting clause by clause on that bill. If there's areas you think that we can refer, that we can deal with in our review, then drop us a note on the specifics of it, and we'll have a look at it.
We can do that, but I think as a practical matter, if you let C-59 pursue its course, and perhaps I would suggest be inspired by some of what is in Part 4, and then translate it into any recommendations you would make to amend the act that you are reviewing, I think that would be good.
Okay. Thank you, Mr. Kelly.
Thank you. I have some questions that come to me based on I have a lengthy career in the mortgage business, and through many seminars for years and years, and including course material when I was a pre-licensing instructor, come from a general assumption in that industry that there is tremendous amount of money that is laundered through real estate transactions. And I'd like both Service Canada and the CRA to maybe comment on this. We know that large, complicated, international money laundering schemes are something that gathers a lot of attention, and government agencies are right to be concerned about these broad, complicated schemes. But what about the simpler ground level transactions that seem to occur every day? The lower level criminal who deposits money in smaller transactions that don't meet the FINTRAC threshold, and eventually buy property where they launder more cash through in the form of exaggerated rent incomes. These kinds of things that happen every day. How do our institutions catch this type of criminal activity? I'll ask maybe Service Canada to comment first, and then CRA.
I may not be the best person to answer that question in the sense that I'm mandated by the RCMP to help them in their money laundering cases. So it's in terms of what's happening at a more local level, we may not necessarily be called, our services may not necessarily be called upon.
Okay, go ahead.
And for CRA, similarly, CRA gets engaged only when there's a suspect of suspicious of tax evasion. I think it's the role of police, local police, law enforcement to make a determination: is there mortgage fraud going on, and there would they initiate a criminal investigation, and at that point maybe they would like to call in the CRA to say, would you like to have a joint investigation?
Does that happen?
Sorry?
How often does that happen?
That happens pretty frequently. Currently, we have, I would say, 13 joint investigations that we have with law enforcement. That would be the RCMP on others, but we would not be specifically on the real estate, but on joint investigation on large-scale money laundering and tax evasion cases.
Wow, that actually sounds like a shockingly low number to me of investigations, given the assumptions that many have about the scale of offenses that go on. Sorry to interrupt,
those are a joint investigation that we have with law enforcement or securities commission, so joint investigation, but CRA criminal investigation always have on the book around 300 investigations of tax evasion, which some could be in the real estate sector.
I'm going to come back to Service Canada again. So are you saying then that you are not typically called upon by the RCMP or other law enforcement agencies
assistance with these types of investigations?
I'd have to come back with you on more specifics in terms of if we're helping at the very local level. We do help provincial police forces, but in terms of whether it's related to those specific cases that you're mentioning, I'll come back to the committee on that.
Because this really gets to the reason often given for why prosecution for mortgage fraud, prosecution for money laundering through real estate seems to be so seldom, that it happens so seldom that the enforcement agencies don't have the expertise to prosecute, and when other investigative authorities on the professional conduct side hand over a professional investigation to law enforcement, there's still no prosecution. So I am actually interested to know how frequent you are called upon on real estate fraud. If with the few moments that I have left for Monsieur Trayan, you said that you talked about the over-reporting to FINTRAC. Is this what causes over-reporting? Is this staff in financial institutions that are being trained to be too assertive and too aggressive? What leads to the over-reporting that you've identified?
I don't know if my colleague will have an opinion because she is responsible for the group doing the reviews. I'm not imputing bad faith. It may be a question of wanting to do the right thing, acting in good faith and informing a government institution of what they believe is suspicious. Training may be part of it. Are financial institutions properly trained? I know there is training, but what we see objectively on the ground is some level of over-reporting by the financial institutions. Do you have anything else?
I wouldn't add much other than I think it's a combination of factors, and I would agree that there's no malintent, but it's probably a combination of maybe a misunderstanding of the exact rules and then some reporting with a narrative or subjective component as well. So they opt to report in certain cases.
Thank you all. Mr. McLeod.
Thank you, Mr. Chair. I'm listening with interest to the presentations today, and I have to agree with your opening comments that this is a very complex issue, and we've heard from a number of organizations now, and I'm really trying to get a handle on how everything fits together. There's many different departments, organizations. We have Department of Finance, Justice, Global Affairs, FINTRAC, Public Prosecution Service of Canada, Canada Border Services Agency, Canada Revenue Agency, Royal Canadian Mounted Police, Security Intelligence Services, Public Safety Canada, Office of Superintendent of Financial Institutions, all involved. Now, I spent a good part of my life as a politician working with governments, and I know that they don't always have the best flow of information or communication links. So I wanted to ask if maybe if you all could give me a little bit of an answer on how well the information sharing takes place. Is it something you're happy with, or if there's an area of improvement? Could you tell us what that is?
Start. CRA looks anxious on information sharing.
Thank you for the question. CRA always starts with the confidentiality provision of the Income Tax Act. You know, we always see Section 241 of the Income Tax Act as some kind of bubble that, you know, every employee that gets into CRA, the first day, the briefing they have is don't share information. But there's always ways that we can share information. There's 5 or 6 ways when we can share information with law enforcement and the law enforcement community, and also with FINTRAC. The examples I shared earlier in my appearance relates to the Panama Papers. You know, we were almost at some kind of a loss there. That how can we generate a good, solid investigation when we only have business structures overseas? So by having meeting our threshold to initiate an investigation, then sharing information according, because it's in the best interest of the administration of the Income Tax Act, share information with FINTRAC, and then FINTRAC provides us with the financial transaction. So that relationship is key for the Criminal Investigation Division. If I just look over the last few years, we had 125 disclosure from FINTRAC in 2013-14, and 2016-17 we had 209 disclosure, and for just the first 3 quarters of 2017-18 we were almost at 213. So there we receive more information from FINTRAC than ever, but at the same time we contribute also information to FINTRAC when we have active investigation. As it relates to information sharing with law enforcement, there's also provisions there for the CRA to share information with law enforcement when the law enforcement comes to us with either a tax order or when they are investigating serious crimes. There's provisions in the income tax to share information. And then when we have a joint investigation with law enforcement, there are provisions there that we can share information. So although CRA always starts to, is perceived to be a taker of information, we are becoming more of a partner in the fight against money laundering and tax evasion.
Public Works, any thoughts? Or Privacy Commissioner usually is don't share too much. Public Works.
I can maybe start and then Nicolas, you can chime in. Yes, there's many partners. We deal with, we're mandated, as I mentioned, by the RCMP, so they're our main conduit. They will get the information from CRA, and you've heard how they share, from CBSA, from FINTRAC. We'll analyze that information, and if there's information that's missing, we go back to the RCMP, and then they get the information. So we're not directly asking for any of the information.
My question, is it working well for you, for your organization?
We're getting the information when it's available. We've talked a little bit about some of the difficulties being able to trace money and getting information if it's in overseas accounts, and then it's getting a production order and getting that information takes a lot more time, and there's other considerations.
Mr. Thayer?
So, Mr. Chair, I think you won't be surprised by the answer. What I would like to do is to remind the committee of how exceptional this regime is. So yes, the Privacy Commissioner will usually ask for prudence in terms of information sharing. We see the need for this exceptional regime given the importance of the harms of money laundering with organized crime and terrorism. But I would guard against, what will not surprise you, I will guard against over-broadening information sharing, because this is a special regime where you have the financial transactions of people who have done nothing wrong. They're just doing a financial transaction over a certain financial threshold being collected. So this may be okay for the purpose of tackling the harms that the legislation is meant to tackle, but be prudent if not to extend this too much.
Okay, I'll have to move on to Mr. Albus. We're substantially over, Mike.
Yeah, thank you, Mr. Chair, and I just want to thank Mr. Therian for that comment, because there's a tremendous amount of power that is given to these different agencies to act under the law, and so it's just a helpful reminder. Again, there's always a balance to be found. Appreciate you raising that point of view. I would like just to talk to CRA in regards to some statements that have come out of British Columbia again. BC's Attorney General David Eby had stated that he's been made aware of serious, large-scale, transnational laundering of the proceeds of crime in British Columbia's casinos. Have you, to the best of your knowledge, is this true? Has CRA been any part of any investigations with the authorities in British Columbia?
Yes, we are working, in several joint investigations, that it be money laundering or when there is a tax evasion element. I think it has been already confirmed in the media in British Columbia that CRA is part of an RCMP investigation that was made public. So yes, we are indeed aware, and we are working collaboratively with the RCMP on those cases.
I'm very happy to hear that. Is this a BC problem, or is this something that is happening in other jurisdictions in this country?
I would say that money laundering has no boundaries. We see
this type that has been raised specifically because, again, the Attorney General has stated that it's happening. I want to know, is this a BC-specific phenomenon, or are there other cases that CRA is aware of that these kinds of transactions are happening?
CRA is involved in several criminal investigations that relates to money laundering to that scale across the country.
Okay. I'd like just to ask to Public Services Procurement Canada, so is there a particular region of the country where that you are seizing more assets involved in money laundering or other activities, or you know, which are the hot spots for the work that you do?
Thank you. Our collaboration is primarily in Ontario. We work very closely with the OPP in the province of Ontario. I believe BC is the second most active jurisdiction for our case volumes.
Okay. Now, I recognize that sometimes there's a case of being left with the bag, so to speak, where you know, no one wants to say who owns a particular asset, but the courts, I guess, will say then something needs to be done with them. They need to be disposed of. Are there quite a bit of cases though like that, or do you do a lot of investigative work to be able to find out where these are, or it's a practical function. I'm sure you're given quite a bit of authority by the court, but I'd just like a little more explanation exactly how you do what you do.
Generally, our services are provided to law enforcement where there is a criminal accusation, so they've got an accused. There are provisions under the criminal code, I'm not an expert in them, but for abandoned property or property without an identifiable owner. So that generally would be a minority of the cases we deal with. Mostly there is an accused. It goes through the legal process, and then we deal with the decisions handed down by the courts.
Yeah, but again, these are all court-ordered processes, though, right? There's a chance for someone to make sure. Okay, no, again, with my comment, there's a lot of authority that's given to government agencies in these regards. I think that pretty much. I'd just actually like to go back to the Privacy Commissioner one more time, because this is an issue that, you know, it's been bothering me because, you know, for example, I have one of those smartwatches. And so I can't tell if the information about my heart rate, is that mine or is that Apple's? And I think that we need to have a very good discussion in this country about the use of data, and then who retains it and who actually owns that information. I would say that you know, that data was generated from my activities, from my purchase. You know, so are these issues that your office is seized with? As who actually owns that personal and private information versus, have you been discussing these with some of the banks or the Ministry of Finance when we're talking about these things?
So we start from the premise that if the information relates to you and you produced it and you sent it to a company, it is yours. It is your personal information. But of course, you may or may not want to look at the contract that you have with the company that sent you the watch. It may tell you differently. But we work from the premise that it is your information.
But whatever their agreement says, obviously, if Parliament has said this is the law, then statute law would then overwhelm a privately construed contract.
To go back to your question, is this something that we're seized of? This is exactly the kind of issue for which we have recommended changes to PIPEDA, and it deals with the issue of consent, meaningful consent that you may have been given to that organization to handle and manage that information. So this is our bread and butter, and we have made recommendations to Parliament to amend PIPEDA to give us more enforcement authority to deal with these issues.
Yeah. Thank you.
Move on. We've never seen your heart rate go up around here, Dan, because you're always so calm. Oh. Ms. O'Connell.
Thank you, Mr. Chair. Thank you all for being here. I want to start with the Privacy Commissioner as well. Except it's a little bit of a different angle. The other day when we had more of the security agencies and officials before us, specifically people from CSIS, the RCMP and whatnot, And one of the questions I had, and in the conversations we were talking about, it was in regards to, similar to what Mr. McLeod was talking about, the information sharing. And if, for example, CSIS received some information that they would then send to the RCMP that dealt with money laundering, because CSIS doesn't really deal with the further investigation. They'd send the tip. And then the question became, or they might send it to FinTrack, or RCMP might send something to FinTrack. And the question I had was, how do we know, or what oversight is there to see that if a piece of intelligence or information is then sent to the appropriate kind of agency, how do we know it's investigated? How does anybody, are there any statistics on whether or not it was looked at, decided not to pursue or to pursue, and where then that information goes? And the answer I got was kind of twofold. One, that's what the Privacy Commissioner, or the Office of the Privacy Commissioner, could do every 2 years. And the other was the potential for the new committee with parliamentarian oversight. But after hearing the presentation and understanding your office's role, it sounds like that is nothing to do with what your oversight is, or I could be wrong, but that your oversight is really mainly on ensuring privacy is protected and that this information is not overused. But my original question about ensuring that information or tips is being sent to the right place and not just falling in a black hole somewhere, that's not what your office looks at, is it? Or is it?
It is not. It is
Okay.
not what our office is doing. You're perfectly right. Our role is to look at the sharing or disclosure of information and whether it was done lawfully. I think the new review agencies created under Bill C-59 will help, though, because they will look at questions of not only legality but effectiveness of the programs. And your question as to whether tips are acted upon or information is acted upon has more to do with the effectiveness of the way in which the various agencies perform their mandates. So that may be, I would need to look at the mandate of NSIRA, that may be part of their job, but the Committee of Parliamentarians certainly would have a mandate to look at questions of effectiveness of the agencies.
Thank you. I'm glad you cleared that up. Perhaps my question wasn't clear originally, but that, in terms of to the other agencies, but your office was specifically kind of cited as that potential oversight or the ability, and it doesn't sound like that's within your mandate.
Oversight, but with a view to looking at privacy.
Right. So it's not within your mandate, even if you felt there was.
No, it is
okay.
not.
Thank you. In regards to public works and government services, specifically on the seizures side, the chair actually asked this question early on in our study in terms of the question about local law enforcement agencies, whether municipal, regional, provincial, and the issue of the seizures and some of the fines come in through to the federal government, yet the local agencies are putting in a lot of the work in terms of investigations in a lot of cases and partnership. So there is this idea, and I'm curious if you think it's real or overstated, that the local law enforcement agencies would go after or investigate, because usually money laundering or criminal activity, it's not one thing, and they might pursue a drug charge or some other charge that, one, might be easier to prove, and two, the proceeds or any fines would then go to those agencies, whether it's provincial, municipal, etc. So have you heard this? Obviously, they wouldn't necessarily tell the federal government, we're not going to pursue it this way because you get to keep the kind of funds that keep it going. But are there rumblings that this is an issue in terms of the enforcement side and where the proceeds of crime end up kind of going in terms of bottom lines and budgets for police forces across the country?
Thanks for the question. So there is a sharing regime in the regulations of the Seized Property Management Act that allows for sharing with provinces. And so if local police force does the majority of the work, they get the lion's share of the proceeds. Provinces also, many of them, particularly in the West, sort of from Ontario to the Pacific, have introduced civil remedies for criminal actions that are also used. So there are other avenues that can get used. So we have seen a trend in our business volumes from '93 when the group was formed with a single case, through to peak volumes in around 2009 under the Control of Drugs and Substances Act, which is one of the acts that we serve, and then decreasing volumes through 2015, and then more stabilization lately. So there is an ebb and flow, and there's a lot of variation within a given jurisdiction in a given year, as is a normal kind of part of the business. Most of the discussions that we've had with law enforcement about predicting business volumes, is predicting it makes them easier to serve, has related to the competing priorities that law enforcement has to deal with. So things like national security that have emerged as big priorities lately, and then a shifting view through the FAFT evaluation of Canada that money laundering is actually a threat to national security, and therefore should be given increased weight. And so those kinds of thinkings have seen ebbs and flows in our business volumes.
Thank you. Thank you both. Mr. Dussault, be 3 minutes.
Oui, je vais essayer de faire ça vite.
I'll try to be brief. I just wanted to come back to the process that you described for the audits and also for the criminal investigations. In your opinion, is that process effective, or do you think there might be possibilities to make it more efficient? Because currently the file's being passed from person to person to person. Do you think it would be possible to improve the way that process works? I think it does work well. In terms of the civil side of the CRA, the auditors sometimes send information over if they find that there is a certain threshold of criminality. They will then send the file to criminal investigations, which will accept the file and carry out an exhaustive investigation. Then that will be sent up to criminal prosecutions. It's the same process that applies in other law enforcement organizations. When they investigate, they either send it up to the criminal prosecution section or up to the province if they're a provincial or municipal law enforcement agency. So I don't have any particular recommendation as to how to change the system. The criminal investigations program receives most of these flags of possible tax evasion from internally, but there are also a number of files that we do generate ourselves following disclosures that we might receive from FINTRAC or from database searches that we manage ourselves. With the last minute that I have left, you seem to be quite proud of the number of agreements, the 93 tax agreements that we have, and the some 23 information sharing agreements that we have. But not everyone in Canada is this proud of that record. So my question is about the tax information sharing system. Do they really work? And are you satisfied with the relationship that you have with those countries? And are you satisfied with the quality of the information that you receive from those countries through that system? Obviously, different countries have different standards. They don't all collect the same type of information. And taxpayers in those countries often don't even have to fill out a tax return. So, is this a hindrance to your investigations? I don't think that the tax information sharing agreements are a hindrance. On the contrary, I think that we can only gain from having more agreements with a great majority of countries. Also in 2018-2019, as you know, there will be the common reporting standard, so for the automatic exchange of information. And I think that that will really increase the transmission of tax information. And I think we'll see a huge benefit there, both in terms of audits within the agency and in terms of investigations.
Yeah, Mr. Fergus.
Merci beaucoup, Monsieur Terrien. J'aimerais juste mieux.
Thank you very much. Mr. Terrien, I'd like to understand, how does Canada rank compared to other countries in terms of how it protects its citizens' private information? Is there any way we can compare our situation to the US or the UK, for example? Do you mean in this area specifically or generally? Well, generally, but also perhaps you could talk about their systems and their way of protecting private data for similar activities. Well, the systems are probably comparable because the Canadian system actually is based on recommendations from the Financial Task Force, which is an international organization that sets quasi-international standards. So many countries' systems are similar for that reason. In terms of the protection of private data in the public sector in general, I would say that the federal act in question has not been updated since the 1980s, so we are lagging in that respect. Can I continue a little bit?
Well, thank you all. I would say we have the discussion paper from the Department of Finance, which I think most of the agencies have been involved in, or departments, and that is leading in certain directions. But I would say that if any of you have information based on that you think would be helpful to committee beyond that discussion paper, we're open to it. So don't be afraid to either drop the clerk a note or give one of us a call if you have a suggestion of something that we maybe should be considering that we're not. So with that, thank you again for your testimony and your work, and we shall adjourn till tomorrow morning. Adjourn.